In this talk, I will discuss about the Anti-Defection Law and powers of the Legislature. First, about the Anti-Defection Law. The Anti-Defection Law, enacted by the 52nd Amendment in 1985, added the 10th schedule to the Constitution, which provided that a member of a political party belonging to a House of Parliament or a state legislature would be disqualified if A. She or he voluntarily gives up membership of the party, or B. If she or he votes or abstains from voting in such house contrary to any direction issued by the party to which she or he belongs, or any person or authority authorized by it in this behalf, without obtaining prior permission, and her/his action has not been condoned by the party, person or authority within 15 days of such voting or abstention. An elected member of a party would mean one who had been set up as a candidate of the party. A nominated member would be deemed to belong to a party if, on the day of her/his nomination, she or he was member of a party, or if she or he joins a political party within 6 months of her/his nomination. The provision will not apply in case of merger of parties by decisions of at least 2/3 of their members. It will also not apply on persons who do not accept the merger and choose to function as a separate group. A complementary provision in the 52nd Amendment, paragraph 3 of the schedule, also exempted split groups of at least 1/3 of the members of a party. It was dropped by the 91st Amendment in 2003. The Speaker and the Deputy Speaker of the House of the People and the Chairman and the Deputy Chairman of the Council of States who leave their parties on election to the posts are exempted from the provision. They are free to join a party after ceasing to hold the posts. The justification of Anti-Defection Law basically is that when a voter votes for a candidate, she or he reposes a trust unto the candidate as a member of a political party. When the elected member changes her/his party affiliation, she or he should renew the trust. Now about the powers of the legislature. The concept of parliamentary supremacy does not apply in India for the following reasons. First, there is a written constitution that is the supreme law of the land. Second, there is a Supreme Court to interpret the Constitution and its interpretation is binding on all subordinate courts. It means that if the Supreme Court says that the law is unacceptable, it may be freely defied in the country. Third, Article 13 expressly forbids any law, old or new, to curtail any of the rights granted in Part 3rd of the Constitution. Fourth, India is a federation. What parliamentary government means is the parliamentary control over the executive. There is a qualified division of powers between the Union and the state legislatures in India, enshrined in the 7th schedule to the Constitution. The logic of this division of powers goes against the theory of parliamentary sovereignty and makes the Union legislature more similar to the US Congress than the British Parliament. The exclusive power of the Union legislature to make laws with respect to certain matters is laid down in the first list of the 7th schedule. In the second list of the same schedule, the jurisdiction of state legislatures has been laid down. Parliament's concurrent jurisdiction with state legislature has been spelled out in the third list. In special circumstances, Parliament may even legislate on state subjects. On the other hand, the separation of powers characteristic of the US Constitution is blurred in India, making it a parliamentary system. In a parliamentary system, the legislature controls the executive, though in turn is led by it. However, there is no clear provision in the Indian Constitution relating to separation of power between the executive and the legislature. Neither the House of the People nor the Council of States has any executive or judicial power. But the executive in a parliamentary government is responsible to the legislature. The legislature in a parliamentary government has the ultimate weapon of moving a no confidence motion. However, this authority belongs to the House of the People alone. The House of the People escorts over the Council of States in another respect also, that is, controlling the finance of the government. As the Constitution does not make a difference between a no confidence motion and a censure, the rules of procedure of the House of the People or the Council of States does not provide for a censure. In the House of the People, a motion in the nature of a censure is recorded as no date yet named motion. No date yet named motion. Unlike the no confidence motions, such motions receive no priority. On the other hand, the rules for the House of the People provide for a motion of no confidence, while those of the Council of States do not. Rules of the Council of States expressly prohibit a motion in the nature of censure or no confidence. It is not even allowed an adjournment motion which involves a degree of censure. On the other hand, the Council of States scores a point over the House of the People in holding the key to parliamentary legislation over state subjects by means of a resolution passed by two-thirds of its members in national interest. One thing is clear: whereas collective responsibility of the Council of Ministers is a constitutional legal provision, there is no individual responsibility of a minister in the constitutional structure. There are ways by which both the houses can check and monitor, if not control or embarrass the executive. Ministers are members of the legislature and are subject to peer pressure. Members of the Council of States, being senior members of the parties, their pressure can be telling on ministers who may be junior in age and rank in the party. The most effective way is interpellation, that is questioning. 1 hour from the start of a day's proceedings is set as the question hour, when members have opportunity to ask ministers questions on their performances, both written and unwritten. Notice is required for such questions to prepare the ministers to answer. The answers have to be correct, or the minister will face privilege proceedings. Members may ask for short duration discussion on a subject without voting. They may call the attention of ministers to particular matters. They can mention matters. They may present petitions to a house, either themselves or on behalf of the public on public interest. They may move resolutions in a house expressing opinion on matters. Members of the House of the People going to the extent of even disapproving of an act or policy of the government. They may move adjournment motions demanding urgent discussion of a matter, suspending the proceedings of the House. Such a motion suggests that the executive has hitherto ignored the important matter and is censorious. They are not allowed to the Council of States. A practice of 0 hour immediately following the question hour has evolved outside the frame of rules. Members at that time may raise what they consider urgent matters. This is in brief about the Anti-Defection Law and powers of the legislature. In my next talk, I will discuss about the legislative procedure. Thanks for patient listening.